Hello everyone. Today we will talk about the separation of power. Separation of power is division of the legislative, executive, and judicial function of the government. The legislature has the power to make and change laws. Judiciary has the power to make judgment on laws, while executive has the power to put laws into action. The term separation of power is coined by Montesquieu in his book Spirit of Law. According to this doctrine, there should be a clear-cut division of power between three organs of the state, in such a manner that same person should not be the part of more than one of the three organs of the government, and one organ of the government should not interfere with the other organ of the government, and one organ of the government should not exercise the function assigned to any other organs. Like ministers should not be the part of parliament, judiciary should not be the independent of the executive, ministers should not be assigned any legislative powers. And its significance in the democracies are it ensures that the power is not concentrated, and it ensures that a government of law rather than the wills and whims of the officials. It ensures independent judiciary and hence a fair government and proper justice to the people. It ensures checks and balances in the system. And now we will talk about the constitutional provisions ensuring separation of power. Article 50 state Article 50 states that states shall take steps to separate the judiciary from the executive, and Article 121 and Article 211 says that judicial conduct of a judge of the Supreme Court and High Court cannot be discussed in the Parliament and the state legislature. While the Article 122 and 212 also state that the validity of proceedings in the Parliament and the legislature cannot be called into questions in any court. Like actually it prohibits the court to inquire into proceedings of the Parliament and state legislature. Article 53 and 154. Executive power of the Union and states shall be vested with the Parliament and the Governor, and they enjoy the immunity from the civil and criminal liability. Article 361 states that President or the Governor shall not be answerable to any court for the exercise and performance of the power and duties of his office. In India, separation of power has been considered as one of the basic features of the constitution. However, the functional and personal overlap can be observed. Executive is the part of legislature and are responsible to its lower houses. Judiciary has the power to declare any law or executive actions as null and void if it violates the provision of the constitution. Executive has the role to play in appointment of judges. Legislature may also perform judicial functions like if the president is to be impeached, both the houses of the parliament are to take an active participatory role. This shows that instead of adopting a rigid separation of the power like in USA, India opted for a unique separation of power with the sufficient checks and balances. Checks and balances reflected in Indian polity. The Constitution ensures that the discriminatory power bestowed on any one organ is within the democratic principle. Checks and balances ensure that no one organ of the government become too powerful. The judiciary has the power to judicial review over the actions of the executive and legislative. It has the power to strike down any law passed by the legislature if it is unconstitutional or arbitrary as per the Article 13. The legislature also reviews the functioning of the executive. It can alter the basics of the judgment while adhering to the constitutional limitations. Although judiciary is independent, the judges are appointed by the executives. And what are the issues with the separation of power? It weakened the opposition in India. Judiciary being averse to checks and balances, Supreme Court has held 99th Constitutional Amendment, which provides for the establishment of the National Judicial Appointment Commission as ultra vires, like beyond the powers. Judicial activism. In many recent judgments, the Supreme Court has become hyper-activist in making judgments that are deemed as laws and rules. Executive excesses. Executives in India is alleged of over centralization of powers, weakening of public institutions, and passing laws to strengthen law, order, and security of the state, but curbs freedom of expression as well. Judicial pronouncement on separation of power. Keswanandan Bharti case 1973. Supreme Court held that the amending power of the Parliament is subject to the basic feature of the Constitution. So any amending violating the basic feature will be declared unconstitutional. Indira Gandhi versus Raj Narayan case 1975. Supreme Court held that settling dispute is a judicial function and Parliament cannot exercise this function. And in Swaran Singh case 1998, Supreme Court held that the UP governor's pardon of a convict constitution.